You're very, very welcome to another exciting webinar from the European Maritime Law Organization. My name is Vincent Power, and I have the honor of being the current chairman of the organization. When I took over and was asked to take over from Lord Nicholas Phillips, the expectation was that it would be, every pun intended, somewhat plain sailing. COVID then hit, and the annual meeting and the spring seminar never occurred. Instead, what we've done in EMLO is we've gone for the webinar model. And so far this year, for example, we've had some fantastic webinars. In January, we had a webinar to review all that happened in 2020 and a preview of 2021. In March, we had a webinar which was based out of Washington, D.C. on U.S. maritime policy under the Biden administration. In May, we had a really fascinating webinar again with people contributing from Italy, from Singapore, from Europe, and around the world on COVID, a retrospective and the very human aspects of COVID in the maritime sector, which have been quite tragic and very moving. In July, we had the first ever two-day webinar where we dealt with decarbonisation of shipping, Fit for 55. And last month, Marjorie Holmes organised a great webinar on the Whistleblower Directive. So we've had really interesting and novel webinars, and we've had the first webinar where all the speakers were women. And today we have a webinar where all the speakers are men. And it really is a fascinating organization to join. And if you were to join now for 2022, you'll get 2.5 months free by joining now, and you won't then have to renew until 2023, by which time we'll all be back in offices and back to normal, etc., etc. And you'll have the opportunity to meet, hopefully during 2022, other members of EMLO, etc. So emlo.org is the way to go, and that would be the ideal thing to do. And why should you join? Well, today's webinar is about EU and UK trade policy in the 2020s. And you'll have an opportunity to hear from what they would describe themselves as three wise men. They need no introduction because the three of them are well able to introduce themselves. But Fergus, who is going to lead the panel, will introduce each of the speakers momentarily and the panelists. But they really are quite brilliant at what they're doing. They are all well known to you all, but Fergus Randolph QC, who's with Alpha Lex Avocat in Brussels, and also at Brickcourt Chambers in London. And that's where he's coming from today. And he is going to talk about the UK-EU Trade and Cooperation Agreement. It's a huge work, as you know, so he's going to focus in on rules of origin in the TCA. Then we go over to Brussels, and Mark Clough QC from Denton's in Brussels is going to talk about indications from the first anti-dumping transition reviews and the lessons we can learn for future anti-dumping practices. And then from Mark, we go back to London. Much like the renegotiation of the Brexit talks, there seem to be eternity ferrying between Brussels and London. We go back to London, and Philippe Rutley from Watson Farley Williams is going to talk about the European Commission's proposed new regulation on foreign subsidies. So it's a really exciting webinar. Please stay with it. Moreover, please join EMLO. There are really exciting things planned for next year, 2022, so be part of them. So I hand you over to the capable hands of Fergus Randolph QC, who will introduce the panel and moreover kick off the proceedings today. And thank you for joining us.
Thank you very much indeed, Vincent. And thank you to our attendees. I'm delighted to see the numbers are growing almost every second, so that's delightful. I'm going to just crack on because it's coming up to 2:10, and we're going to try and get through this by about 3:10. So as Vincent said, the TCA, I'm looking at an electronic copy of it in the official journal version, which is the version you should all read and use because it's been renumbered from the one that was published on Christmas Eve. That is some 2,530 pages. and it would take more than the 15 minutes slot allotted to me to go through that. So I'm concentrating, as Vincent said, on the rules of origin. Next slide, please. We're going to look at the TCA provisions briefly. We're then going to look at some EU materials that have been published relatively recently during the course of this year, and some materials from the UK, from gov.uk, that were published on my birthday, as it happens, the 6th of October. And then we're going to briefly round up with a discussion, possibly a short discussion, on why the rules of origin might be relevant to the shipping industry. Next slide, please. Now, the origin, as this slide makes clear, the origin of a product might seem to be a relatively academic issue. It's extremely dry and very technical. But as Article 21 of the TCA points out, except as otherwise provided for this agreement, customs duties on all goods originating, that word is underlined deliberately, in the other party shall be prohibited. So if you can show that your product that you're importing from the UK into the from the EU into the UK, or from the UK into the EU, comes from, originates technically from the UK into the EU, or the vice versa, then customs duties shall be prohibited. Now, there are all sorts of non-tariff barriers that are not prohibited under the TCA, and that's an issue, but we're not going to deal with that today. We're dealing with rules of origin. And as Article 37 says, the objective of this chapter, and it's chapter 2, is to lay down the provisions for determining the origin of goods for the purpose of application of preferential tariff treatment. And that preferential tariff treatment is, in short, that which is set out under Article 21, i.e. no customs duties, for the purpose of applying that treatment under this agreement and setting out related origin procedures. And trust me, there are lots of them, and there are annexes, and you could spend a happy few hours going through annexes 2 and 3, setting out all sorts of specific working on, or workings, or manufacturing processes on particular types of products that constitute sufficient working, and we'll see that in a moment. Now, Article 39 of the TCA is the meat in the sandwich. What do originating products comprise? Either wholly obtained in the EU or the UK, that's fairly obvious. So to take an example, if one has a product, let's say a farming product, let's say a farming animal, let's say a chicken, that is bred and slaughtered and butchered in the UK, that will be a UK chicken, which can then be exported to the EU without having any customs duties imposed on it. That's very straightforward. Little 2, products produced in either the UK or the UK from originating materials in either location. So again, it's not wholly obtained, but it's materials that originate. So that's where you are manufacturing something from components, all of which come from the UK. Or the third point is products produced in either the EU or the UK incorporating non-originating materials, providing they satisfy the requirements relating to product-specific rules of origin. And this is where things get a little bit complex. What happens if you are making a car, for example, and you are sourcing chips from, as in electronic chips, from Japan, and you are sourcing the car's seating from Turkey and the engine from Germany. It all gets quite complex, and you will get into, and we're not going to go into it in the remaining 10 minutes I have of my talk, into working out the value added and to see whether it comes up to a relevant percentage so that that product can be deemed to be incorporated either in the EU or in the UK. So it can be either one in order to avoid customs duties. Next slide, please. Accumulation. Now, this is slightly complex. Article 40, a product originating in a party, either EU or the UK, should be considered as originating in the other party, so the UK or the EU, if that product is used as a material in the production of another product in that other party. So again, you're bringing in, you're using products from the other party as part of the manufacturing process or the general process, doesn't have to be manufacturing, it's just a process, pursuant to which you are making a finished good. Now, Annex 2 I mentioned, note 3.1 is quite important because it flips back to, or it cross-refers to Article 39. You'll remember Article 39 with the 3 points defining what constitutes originating products. Article 39 applies whether or not the status has been acquired, so the originating status, inside the same factory in a party where these products are used. So it doesn't all have to be manufactured in the same place. It can be done in stages, and that will often be the case with, say, a car, which I think someone worked out, cars could, and parts of cars, cross the channel certainly prior to Brexit in any event, many times before the final product was rolling off the production line. Annex 3 is where you can have fun and look at what kind of specific processes, say involving tanning of animal skins or other matters, comprise sufficient working for the purpose of originating materials. And Annex 4 is very niche. It refers to origin quotas. There aren't quotas generally, but origin quotas specifically for tuna and aluminium, and probably watch this space for some change to Annex 4, depending on political and economic events. Next slide, please. Origin procedures are set out in Article 54. The main process of claiming origin rests on the importer's shoulders. You can do it through an exporter's declaration of origin, but often it'll be the importer's knowledge, and I'll come back to that in a moment. But essentially, qua importer, and this is where it may be relevant, this whole issue may be relevant to the shipping industry, qua importer, you bear the burden of proving that the goods originate in the relevant party. In other words, the other party. In other words, if you're importing into the UK, you will need to be showing that the origin of the products you're importing is the EU and vice versa. Article 61, Customs Authority of the importing party may conduct a verification. Yes, and we'll see in a moment what the EU guidelines published earlier this year say about that. And finally, 64.4, in all cases, the settlement of differences between the importer and the Customs Authority shall be under the law, shall be determined under the law of the party of import. So UK importer, it'll be English law, Scottish importer, it'll be Scottish law, etc. Next slide, please. Now, EU materials, I can be brief. For the audience's benefit, it looks doesn't come up very well there. Whoops. Anyway, sorry, that doesn't work. Live action doesn't work on this. Anyway, it is it's a relatively short 35-page document published on the 5th of February by the European Commission and covers all of those points listed on that slide. I just want to pick up on the point I was mentioning earlier about importers' knowledge. And at 5.2, if you see this document, it makes the point that the importer's knowledge is one of the two bases. The other one is exporter's declaration of origin for the importer to claim preferential treatment. It allows the importers to claim preferential tariff treatment merely based on its own knowledge about the originating status of imported products, well, that's fine. But then, of course, it's all very well you saying, oh, my knowledge is such. But of course, customs, where you're importing, can say, well, we're not terribly convinced about that. So there's a possibility to verify what the documents and the knowledge. And step one, as can be seen in 6.2 of this document, says that the importing customs authority requests from the importer no more information than provided in the list of data elements in a particular relevant article. And just note, you'll see at the bottom of this slide, cross-reference to provisions in this document is to the old numbering, which is deeply unhelpful. And I'm hoping very much that this will be updated, because the numbers just don't match up to the proper numbers that we now have in the official journal. So that's step one. And step two, in case the importing customs authority needs more information determining the originating status of the product, and following step one, the importing party may request the importer to provide further details. And as all information demonstrating that the product is originating and satisfies the requirements provided for in the relevant headings should be available, the importer, and this is important, is under the obligation to provide the requested information to the importing customs authority. Non-compliance will result in a denial of preferential tariff treatment, and as appropriate, administrative measures or sanctions. So the onus is very much on the importer to make sure that he or she or it has their ducks in a row. And if their ducks are not in a row, then not only will customs tariffs be imposed, but there could be administrative sanctions as well. Next slide, please. Right, the UK materials, I can, as it says, they were reissued on my birthday, which was very good. And they cover, you can get them off the website, gov.uk, and it covers a range of issues that you can see on that screen. And I'm not going to go through them now. However, there are, you'll see point 7, Roman 7, case studies for insufficient production. They are useful, especially if you have a case where you can seek to draw the conclusions from gov.uk as to what constitutes sufficient and insufficient production. But of course, that is not legally binding. It's just a guideline. Next slide, please. Accumulation. Now this, as I say, could often be the most tricky issue in practice. What amount of production or work carried out within the UK or the EU using non-originating materials, which is the Turkish, Japanese electronic chips point, is required to allow the end product to be deemed as originating in the relevant party. Hugely important for the reasons that I set out there and I've already said. And essentially the test is one of sufficient working, and sufficient working or processing will be determined on the basis of either the amount of value added by the relevant component, or a change of commodity code by the working or processing, or the manufacture from certain products, or through specific processes. As I discussed the useful case studies, this is extremely technical and requires essential reading of all the technical data, including annexes 2 and 3 to the TCA. Next slide, please. Now, why is origin or origin rules under the TCA relevant to the shipping industry? Well, clearly prior to Brexit, prior to the TCA, just signed off on last year, essentially there was none of this because everything was tariff-free in any event, and there was no need to go through these particular hoops. And they are hoops. And what I think will happen is what has happened already. There are supply chain problems, as we all know, and one of the problems is legal uncertainty, which may be a benefit to lawyers, but a disbenefit to business. And insofar as importers are unable to get their goods out of the port, not particularly because of HGV drivers, but because of customs clearance, because there is verification going on and their goods have not been moved off port to another site, then that will lead to backup and backlogs and log jams and possibly create further issues. To date, I'm not aware of that many cases being dealt with, certainly not before the courts. There may be in an administrative sense, but I think watch this space, and I am pretty sure that there will be some test cases being brought, particularly at the EU end, with EU importers of UK products, which are said to be UK originating. Right, that's enough for me because it's 14:25. I'm now going to pass on to Mark Clough, who is at Denton's in Brussels, and he and I have known each other for very many years and worked on dumping cases in the past. Happy days they were indeed. And Mark is now going to tell us all about the new UK anti-dumping law and international trade issues. Thank you very much. Off you go, Mark.
Thank you very much, Fergus. Keep a watch on the time for me. Good afternoon, everybody. It may be slightly ironic that I'm in Brussels, as Vincent said, when I'm talking about UK anti-dumping law, but I happen by accident to have been involved with my colleagues in one of the first transition review cases in the UK. So that's why I'm going to share what is just a very small point, really. But let me have the first slide, please. I'm going to talk very briefly about the legislation, just to give you a poster to that, and then the first cases in outline, and then my comment on the international trade law issues and why I say that there's something a little bit wrong with the specific transition review procedure. Next slide, please. So we have the UK Trade Act 2021, actually last in order, but been hanging around as a draft law for a long time, and introduced eventually what's called the Trade Remedies Authority, which is the official trade remedies enforcement body in the Department for International Trade, but only with effect from the 1st of June of this year. And as you can see, the TRA, as it's known, is an executive non-departmental public body sponsored by the Department of Trade, the Department for International Trade, the DIT. And sorry, I just got I've lost the slides. Hang on a second. I don't know if Tessa, you can help me. I seem to have lost the slides. I've got Fergus. Well, forgive me, I can't see anything at the moment, so I'll just go ahead. The TRA took over responsibility for the UK. Can you hear me, incidentally?
Yes, we can. Thank you very much.
I'm sorry, I can't see anything.
You're doing well. We can hear you, and we're listening to you with interest.
Okay, great. Sorry, well, I can't see the slides, but anyway, it took over responsibility for UK trade remedies investigations, including transition reviews, which had been carried out until June of this year by the DIT Trade Remedies Investigations Directorate. That's the TRID, or TRID, on a temporary basis. There are two main pieces of legislation of relevance to dumping. The first primary legislation is the Taxation Cross-Border Trade Act of 2018, known for some reason as the Taxation Act. Schedule 4 describes how dumping investigations should be carried out, and indeed Article 2 of the WTO anti-dumping agreement itself provides guidance on calculation of dumping margins, which is actually followed by the TRA and before them the TRID. The secondary legislation is the Trade Remedies Dumping and Subsidization EU Exit Regulations 2019, known as the DNS regulations. And again, part 2 of those regulations, for example, covers the calculation of dumping margins. I won't go into the technical details of dumping procedures, but before I move on to the cases, let me just explain very quickly to those who may be not familiar with anti-dumping, which I expect is very few of you. But anti-dumping duties, and indeed price undertakings, which can be used instead of duties, are permitted to be imposed on member countries of the WTO companies, exporters, when they establish that sales of certain defined products by their national industry are being damaged by the unfairly low prices of exports of like products from another country. Article 6 of the GATT provides for this, and then the details are found in the WTO agreement on anti-dumping, which lay down the rules applicable to anti-dumping investigations and permissible remedies. They allow exports from countries which are found to be dumped to be subject to extra duties as an exception to the principles, for example, of non-discrimination and most favoured nation treatment applied to trade restrictions, generally including tariffs, by the WTO agreement. Dumping only occurs where the relevant authority finds that the price charged for goods for export, that's the export price, is less than the price charged in the domestic market of the country of export for the like product known as normal value. Once dumping is established, the authority has to establish that its domestic industry is being injured by dumped imports of like products, that is, injury or threat of material injury. This is normally evidenced by loss of sales volume, reduction in sales value or prices, loss of employment, and reduced investment, ultimately resulting in loss of profit. Any injury caused by other factors than dumped imports, such as low price imports from a country where those prices are above its normal value level, must be ignored in the injury margin calculation. In addition to the three main ingredients, the WTO rules are silent regarding the use of a criterion akin to a public interest test. This is very important, this test. It allows the interests of customers, importers, and the impact on the supply chain or economy generally to be taken into account. If the test is not met, the investigating authority may decide not to impose anti-dumping measures, even if dumping and injury are otherwise established. In the EU, this is called the union interest, previously the community interest. In the UK, under the Taxation Act 2018, it is called simply the UK interest. The UK legislation and guidance, of which there are a great deal and very helpful, follows closely the permitted WTO rules. It also has adopted much of the practice of the European Commission in the guidelines and procedures such as sampling and verifications. There are some divergences, such as the consistent use of the lesser duty rule, permitted but not required by the WTO anti-dumping agreement. This allows the dumping duty to be lower than it would be if only the dumping margin were used to calculate the duty, as opposed to the injury margin. In the United States, if there's just one step of injury, that justifies imposing anti-dumping duties on the basis of the dumping margin. The EU now has a slightly ambivalent approach, but the UK is clear that it's keeping the lesser duty rule. One of the cases I'm about to quickly run through in outline, literally listing them, the authority relied on the UK interest test, and it therefore demonstrates the importance of the application of the UK interest test. In the first anti-dumping transition review decision, where the duties imposed on what are called PSC wires and strands have been terminated in the UK interest, because the complaint by the sole representative of the relevant UK industry said they no longer wished to pursue their complaint, rather than respond to an information deficiency notice presented by the TRID, now the TRA. This is also a good example of the thoroughness and apparent absence of political influence in the UK practice so far, unlike, I might say, the European Commission. Finally, although the European Court of Justice is not involved, appeals may be made to the lower tribunal and then to the Higher Court and Court of Appeal, High Court and Court of Appeal. Thank you. We've got the next slide. listing the first UK anti-dumping cases and transitional reviews. The very first anti-dumping case didn't take place until the 21st of June, when anti-dumping case number 12, aluminium extrusions from China, was initiated. But there have been 12 transition reviews of EU anti-dumping, subsidy, and the steel safeguards measures initiated since the UK left the EU on the 31st of January 2020. 8 concern EU anti-dumping expiry reviews, 3 the equivalent anti-subsidy reviews, and 1 the transition steel safeguard review, which is now subject to what you might call a political review. 4 of the 12 cases have entered their final phases, 1, 3, 2, and 6. The procedural and substantive documents and decisions relating to all trade remedy cases are available on the TRA website, which is very useful, and there's a link in this slide to that website. On the 25th of June 2021, the Statement of Essential Facts, that's effectively the draft decision, was published by the TRA in the Anti-Subsidy Transition Review number 2, Rainbow Trout from Turkey, recommending to vary the countervailing amounts. But instead, they chose to maintain the current amounts in the absence of sufficient data to vary them. This demonstrates, if you like, the caution, which is perhaps welcome, of the TRA and the TRID before it, in how it deals with the evidence that it actually can obtain. Next slide.
Sorry, 5 minutes, if we might.
5 minutes is more than enough. Yeah.
Perfect. Okay. Thank you so much.
Previous slide, please. Yeah. Okay. Thanks, folks. On the 19th of May, the Statement of Intended Final Determination was published by TRID in the safeguard measures case, and as we've seen, that's now subject to a political review. On the 14th of May, the Statement of Essential Facts was published in the first anti-dumping transition review, welded tubes and pipes from Belarus, China, and Russia, stating its preliminary intention to recommend variation of the duties, but choosing to propose maintaining them for 5 years. Only one of the transition reviews has been determined at this time, and that's the first, the case I've already mentioned, the PSC wires and strands, pre- and post-stressing wire and strands originating in China. And this case was initiated on the 30th of July 2020, just to give you an idea of the timetable, and was closed on the 2nd of August 2021 without any action taken. The original anti-dumping duties were imposed by the European Commission in 2015 and have been the subject of an EU expiry review. Next slide, please. Now, finally, the issue, which is in a sense a simple one, and one that not all might agree with. In my view, there are fundamental flaws in the UK's trade remedies transition policy and transition reviews legislation that has been applied or is being applied to the 8 EU anti-dumping measures during the transition period. The transition review procedure constitutes a fundamental breach of international trade law. In my view, it is inconsistent with the international rules on anti-dumping incorporated in the GATT 1994, Article 6, and the WTO Agreement on Article 6, GATT 1994, which I've already mentioned, govern anti-dumping. It also has no legal basis under the EU legal system, which applied to the UK until the expiry of the transition period. What do I mean there? It is clear from, for example, Article 11 of the WTO anti-dumping agreement that the authority that deals with a review, that the heading of Article 11 is duration and review of anti-dumping duties, including standard expiry reviews, that it's clear from Article 11 that no anti-dumping duty may be imposed by a WTO member unless its authorities determine that the effect of dumping is to cause or threaten material injury or to retard materially the establishment of a domestic industry. Second, an anti-dumping measure may only be applied under the circumstances provided for in Article 6 of the GATT 1994 and pursuant to investigations initiated and conducted by the relevant authorities in accordance with the WTO anti-dumping agreement. And finally, a definitive anti-dumping duty must be terminated not later than 5 years from its most recent lawful imposition, unless the authorities determine in a timely review, initiated on their own initiative or on a duly substantiated request by the domestic industry, that expiry would lead to a continuation or recurrence of dumping injury. We've already seen that the first transition review to be decided was terminated. The second decision, though, was not a termination decision, as we've also seen. But it's too early to predict the outcome of all the other transition reviews. But in the light of the informal challenges rumored to be made to the WTO Secretariat by China and Russia, it would perhaps be diplomatic for the UK to terminate them in the same way as it did the PSC wire case. This would avoid leaving the WTO dispute body to decide at a future date what the answer to the following question is. Does Article 6 of the GATT and the WTO anti-dumping agreement permit the review of anti-dumping duties by an authority which is not the same as, nor any longer even related to, the authority which imposed the original duties? And by that I mean where you have duties imposed by the European Commission, and then you have a UK transitional review and the Department for International Trade, the TRID, carrying out the role of the authority. It's clear they're not the same. Thank you very much, folks.
Brilliant. Thank you so much, Mark. Very interesting question. And also rather interesting your mention of would the UK be diplomatic? Well, that's a question in itself. Passing on to diplomacy side, we get to Philippe Ruckley, Senior Advisor of Watson Farley Williams, man who established EMLO in the mists of time. And luckily, I have proof of said mists of time by virtue of an article from the Times, and that can doubtless be on the EMLO website. I will pass over to Philippe, who is now going to talk about the EU's proposed regulation on foreign subsidies. Philippe.
Thank you very much. In fact, it was nearly 30 years to the day that EMLO was created, in fact, more than 30 years to the day. So we have a bit of history today in this seminar. Ladies and gentlemen, I'm delighted to be addressing the EMLO seminar today. In some ways, I'm in the worst and possibly the best situation of the three speakers. The worst because I'm speaking after the last three excellent speakers who've talked about solid law. But in some ways the best situation because today I'm talking about an as yet non-existent EU regulation. Next slide, please. So I want to quickly survey an important new regulation proposal by the Commission to combat foreign subsidies that distort competition in the internal market. There are quite a lot of slides. I'll in fact go quite quickly through the procedural aspects, which are very similar to mergers and competition procedures, and the fines and other sanctions and remedies are familiar to most people today. So I'll skip through this. But the essence of this new proposal is to deal with the problem of an entity buying or acquiring through a merger an EU target with artificially greater funds than would be normal would be available to competitors as a result of foreign subsidies. Another example of harm to the internal market would be foreign subsidies which allow a bidder in a public procurement tender to make an unusually low price and thereby get a competitive advantage over their rivals. Now, the problem, of course, is that the existing regulations and the existing powers of the EU do not cover this situation for the obvious reason that EU state aids relate to subsidies or aids granted by EU member states, not by foreign countries. Public procurement rules are, of course, limited to those applying inside the EU. There's also the WTO subsidies agreement, the agreement on subsidies and countervailing measures, the SCM agreement, which does cover subsidies, but only in goods, but not in services. And the WTO general agreement on trade and services doesn't deal with subsidies. So you do have a regulatory gap, which the Commission is determined to do something about. It's a quite a politically charged proposal, but we are living in the post-Trump period. We have trade challenges from China and other countries, and of course, a very assertive and combative post-Brexit UK. There's been a lot of support for this new regulation from major member states like Germany, France, Italy, the Netherlands, and Poland. And it's perhaps a sign, an indication of the enthusiasm for this regulation that it was first proposed in June 2020 and has already now been unveiled as a draft regulation by May 2021. So almost a record speed, which I think is an indication of the support for the regulation in Brussels. Next slide, please. It is partly, I think, a reflection of the new EU policy of open strategic autonomy, i.e. creating an EU which is open to trade and investment, but also assertive against unfair and coercive practices. Next slide. The regulation proposes three very significant and rather sweeping powers. The first one, the Commission will have the powers to investigate foreign subsidies distorting competition ex officio, out of its own motion, and where necessary, having done that investigation, impose remedies. More specifically, there's a second power, second tool for the Commission to block or suspend mergers if they are negatively or unfairly affected by foreign subsidies, and again another power to block public procurement awards where they are affected by foreign subsidies. Next slide. Now, it's very important to remember that this regulation applies to both non-EU undertakings, i.e. a Japanese company, and also to EU undertakings who are operating in the internal market but have received subsidies from third countries. So this would cover, for example, a German company receiving a subsidy in India, as much as a Japanese company receiving a subsidy from the Japanese government and operating in the internal market. Next slide. I won't go through too much law, but if you look, I've indicated the relevant articles of the draft regulation. Article 2 talks about foreign subsidies, which is defined as a foreign financial contribution conferring a benefit to an undertaking operating in the EU internal market. And the regulation then gives examples of financial contributions, which are quite standard in terms of international trade, such as transfer of funds or grants or loans, tax assistance, tax holidays, rescheduling of debt, and so on. Next slide. Of course, once you have identified a foreign subsidy, you have to decide whether it does distort the internal market. And then the regulation proposes a scheme of analysis which amounts to a consideration of the amount, the nature, the purpose, and the conditions of the foreign subsidy and its use in the internal market. Then Article 4 makes it very clear that the most likely distortive subsidies are those which are given to ailing undertakings, which involve unlimited financial assistance, subsidies directly facilitating a merger or enabling an unduly advantageous tender. There is happily some form of restraint from the Commission's proposal in that the de minimis threshold for the application of the regulation is where the amounts of the subsidy are over 5 million euros over 3 consecutive previous fiscal years. And I would note that this is 20 times the de minimis threshold under EU state aid rules. Next slide. So there is, of course, a balancing exercise required by Article 5 that you have to see where the foreign subsidy and its effect, in fact, create benefits inside the EU. But I suspect it's going to be likely to be quite controversial because in the EU state aid cases, which Mark and Fergus will know far better than I do, the debate often focuses on arguments concerning the job creation or preservation or helping a disadvantaged area of the EU and so on. But here, in the analysis of a foreign subsidy, you're much more likely to have political decisions because unlike EU state aids, you could easily have a national champion of a foreign company or a third country, which is very successful and doesn't really require much finance, but is nevertheless subsidized by its government to then have which leads to a competitive and distortive advantage in the internal market. So I suspect that robust assessment criteria will be needed and may well be developed in case law derived from this regulation. Next slide. So as I said, there are three basic Commission powers: the General Commission power to investigate, then power to investigate in mergers and in procurement bids. Next slide. So let's have a quick look at the ex officio Commission investigating powers. Firstly, it's likely there will be a market investigation, and that where that market investigation, or shall we say the microchip market or the shipping market, the Commission concludes there's something to investigate, then it will conduct ex officio investigations of foreign subsidies in that particular market. Note that the Commission will have powers to investigate both within and outside the EU. It will be able to investigate in a third country, obviously with the consent of the third country, but the regulation provides that where the third country is not cooperative, then the inferences will be drawn from this and the Commission will take a decision based on the evidence it has managed to gather. Next slide. So you have first a preliminary investigation through requests for information, and then you can have, in fact, dawn raids, inspections within and outside the EU, which then leads, if there is a conclusion that there has been a distortive foreign subsidy, the Commission will take measures known as redressive measures, which might require the repayment of the subsidy or reducing capacity in the market or market presence in the market. The defendant will be allowed to offer commitments, and there will also be commitments to repay the subsidy or reduce capacity, as the case may be. And there's also provision for interim measures. Next slide. Note that these ex officio investigation powers are distinct from powers to investigate foreign subsidies affecting mergers or public procurement. So there are three different types of procedures. It's important to also note that, unlike in the case of mergers or public procurement bids, the Commission can investigate back to 10 years before the start of the investigation. And again, the de minimis provision applies. Foreign subsidies above 5 million euros in the previous 3 years are relevant. Next slide. Then, of course, you have a power, as I mentioned, for the Commission to vet mergers affected by foreign subsidies. There's there's a compulsory notification system where the party involved in a merger, a transaction, must notify the Commission if the target of the merger is established within the EU with a turnover of over 500 million euros, and that the acquiring undertaking has received an aggregate foreign financial contribution of 50 million euros in 3 calendar years before the notification. Now, of course, this power of vetting foreign mergers applies in parallel to existing and continuing merger control or foreign investment review proceedings. Next slide. I'll very quickly skip through. The procedure is the same as in the merger regulation. You have phase 1 and phase 2 with the same time limits. Next slide. In public procurement, you have a compulsory notification where the bidder who has received foreign subsidies is under an obligation to notify the contracting authority of any foreign financial contributions received where the public tender's value is worth more than 250 million euros or more. The interesting thing is that the bidder is also required to confirm that it has not received foreign subsidies. So if you like, you have a negative and a positive duty, an obligation to notify received subsidies, but also an obligation to notify the contracting authority that you have not received foreign subsidies. And once the contracting authority has received a notification, it must then send it to the European Commission for its analysis, which I'll come to on the next slide. The Commission has 60 days to examine the notified bid, and then an additional 140 days to investigate the public procurement bid to determine whether it is compliant. And if it comes to a decision that it is based on unfair foreign subsidies, then it can take action in terms of redressive measures. Most likely, I would expect there will be commitments to review the bid being made by the foreign company or the company receiving foreign subsidies to produce a revised bid for the tender. Next slide. Actually, I won't go to that slide. That's more technical. Next slide. The redressive measures, as I mentioned, can be traditional measures such as allowing third-party access to subsidized infrastructure, prohibition on investments, divestiture of assets, which I suspect is going to be very controversial, or even the repayment of the foreign subsidy with an appropriate rate of interest. So that would be interesting if they're trying to do so to a company in a state economy country which has received subsidies which are subject to this regulation. Next slide. Very quickly, I'll mention the fact that our fines and periodic penalty payments, they're the same in essence as what you get in competition cases. You know, the maximum fine of 10% of aggregate worldwide turnover if the undertaking fails to comply with a redressive measure, and so on. Next slide. Do remember that the regulation proposed applies to foreign subsidies granted 10 years before the entry force of the regulation, but also specifically in merger or procurement cases, it only goes back 3 years to the transaction or the bid concerned, and it does not affect mergers concluded or a public bid announced and awarded before the date of application of the regulation, and not to public procurement procedures initiated before the date of application of the regulation. Next slide. Well, the Commission expects to be busy. According to its paper and in May, it expects to have 30 mergers and 30 public procurement bids notified annually, and expects to have to allocate up to 145 Commission officials to the new regulation, which is the equivalent of several units within a Director General. And so they are clearly intending this to be a very active piece of legislation. Next slide. Now, there are some really serious implications in this regulation if it comes into force. Firstly, of course, is the higher regulatory burden. I suspect one of the most difficult problems for companies will be how do you identify a foreign subsidy if you think you received one, how do you calculate it, and how do you then calculate the value of the foreign financial contribution, remembering that the consequences of non-notification or incorrect or incomplete notification are very severe, as you will see in terms of the fines which can be imposed by the Commission. Next slide. The other problem, of course, is that, suppose the regulation gets adopted with the enthusiasm which has been noticeable for the regulation so far. Let's say it comes into force on the 1st of July 2023. Any company currently thinking of making an investment by buying targets inside the EU will have to work out whether it has received foreign subsidies right back to 2020, the last 3 years. So one really has a quite considerable planning regulatory burden, which I would highlight very strongly. Next slide. Sorry, I will go on to the next slide in the interest of time. The last one, I think, is to, I would predict a complaints of asymmetry of treatment between those recipients of EU member state subsidies and state aids, where the analysis is going to be slightly different in terms of is the state aid there to help a disadvantaged area or to promote a new innovative technical process, compared to the rather more political process, which I think is likely to happen as a result of these investigations of the Commission, the ex officio investigations, or the specific analysis of foreign subsidies and their impact on mergers or public procurement bids. Next slide. There is, of course, some thought as to the overlap with the WTO subsidies agreement, and there is provision there that under Article 47 that the procedures on this regulation should not clash with the WTO subsidies and countervailing measures agreement procedures. Now, next slide, as we are a maritime organization, there are two aspects of this regulation which cross over specifically into the maritime industry. The regulation at Article 44 subparagraph 4 provides that where in the case of the application of the regulation on the protection against injurious pricing of vessels, the regulation would take precedence. The present proposed regulation would take precedence unless the 2016 regulation on injurious pricing comes into force, and that is dependent on the OECD shipbuilding agreement being in application, which hasn't yet happened. But if it did, then the regulation provides for that. But in the meantime, the new regulation would cover the situation of subsidies leading to injurious pricing of vessels. Next slide. There's of course the old regulation 4057 of 86, the last remaining regulation of that package of 1986 measures in the maritime sector, which is still in force, which is the regulation on unfair pricing practices in maritime transport, and that the regulation provides that the new regulation will take precedence over it, which I think is a reflection of the view that since 1986, when the 4057 regulation came into force, trade law and the analysis of unfair pricing or dumping has evolved considerably, with a lot of precedents in the WTO, and it suggests to me that they now think that the regulation 457 is due to be commissioned and retired, but we shall see. Next slide. So in conclusion, as I know I'm coming to the end of my time, I would say that this is a reflection of a new and aggressive stance of the EU towards third countries, but it will also, I think, face the same problems as always have happened in the application of trade remedy measures in the services industry, i.e. transport. After all, let's remember that there's only been one procedure under Regulation 4057, and that was against Hyundai from Korea, and that was back in the late 1980s. There was a threat to use the regulation against the old Soviet Sovcomflot fleet. And in the aviation sector, where there was a regulation called 808 of 2004, which has now been renewed as a new and improved in 2019 with regulation 712 of 2019 on unfair competition in the aviation sector. That regulation in the aviation sector has never been used, although there have been threats of complaints and so on. WTO dispute settlement in the services industries, including aviation, as we've seen from the Boeing cases are very cumbersome and take ages. You have the panels, then you have the appellate body appeals and so on, and then there's implementation and so on. And I think there's a growing frustration in the Commission, which I would personally share, that in the services sector, the application of trade remedies and serious action against unfair practices is actually much harder to bring into reality than in the manufactured goods sector. But maybe it will make waves. Finally, next slide. In case you are interested in the regulation proposal and the paper explaining the policy behind it, I've given you the reference, and I don't normally plug my own publications, but I have done a survey of the aviation regulation on safeguarding competition in air transport, and in that regulation, in that article, I also cover all the WTO case law on subsidies and compare them to the regulation's proposals and its policy principles in the recitals of the regulation. And you can find that in the February issue of the European Competition Law Review. And if you're interested in French, I've done the same thing for the Swiss Association of Air and Space Law. So that is my last slide, and thank you very much for your attention.
Brilliant. Thank you so much, Philippe. Some 30 slides in less than 20 minutes. Very impressive. I'm going to abuse my position as moderator and maybe ask you a question, if I may. You said that the draft regulation got onto the non-statute book, in other words, into the proposal stage in record time. do you have any understanding about when it might actually be adopted? And is it a co-institutional measure? In other words, is it a parliament? Is the parliament going to be formally involved?
Yes, it is. It is a. It is involved. It is in fact a draft Parliament and Council regulation. So I should have said that. And already there has been some mutterings in Parliament. I think it was Chris Hampel, one of the MEPs in charge of looking at that regulation, has already said, well, we must be careful not to put too much of a burden on EU companies who receive subsidies, and let's not clog up the works with endless investigations and interferences in mergers and public procurement.
Right. And do you know what timing there might be?
No, I heard a very interesting speech at the Collège d'Europe.
Yeah.
By Chris Saufer, I think, from DG Competition State Aids, and he didn't really have, he wouldn't predict, but I got the impression that they are getting on with it, and I think that, you know, it's one of the measures which they want to bring through fairly speedily. I mean, who knows? I mean, we know, you know better than I do how long the European Parliament takes to debate and the Council, but there is a lot of, what is interesting about this regulation is that there's a lot of support from, as I say, France and Italy and Germany, and in some ways I suspect that this is one example of, if I can stick my neck out, where the absence of the UK as a visitor might be helpful, that, you know, the UK would have probably resisted this type of measure, being a much more open, liberal, economically inclined government. But now we have the 27, I suspect, are much keener on protective measures and more aggression towards the outside world. We'll see.
But while you're on your podium, there is a question that has come in, which I will read out. Any idea on the possible applications of the proposed regulation, which is the regulation you've just been describing, to Chinese investments in port terminals, (Silk Road) in the EU?
Well, all I can say is that the European, I think there has been in 2020, and I can find the reference. I think it was the Economic and Social Committee did a paper specifically angled at the at Chinese subsidies. So obviously, it's, you know, of the list of suspects, if I may put it that way, it would be likely that China, which has considerably supported this industry in various areas, would be one of the economies and one of the players in the internal market, which would be likely to be subject to Commission scrutiny. But, you know, one thing that's interesting is, of course, there is no complaints mechanism under this regulation. So, but clearly, a third party can go and talk to the Commission and say, "Oh, what about this? Can you come and investigate this?" But ultimately, the Commission has the power to, you know, to decide when it takes action or not. It can't be compelled to take action.
Thank you very much.
I'll come back to you. I'll come back to you with the thing about the Chinese.
I'm just going to ask Mark a question after his fascinating talk on what I think can only be described as a slow start by the UK Trade Authority. And also, I think the Secretary of State got involved early on in overturning a decision. But would you think, Mark, that the UK is more protectionist post-Brexit than it was before when it was a member of the EU? Now, that might seem a fairly obvious question, but it may not lead to an obvious answer.
Well, I'm going to give you two answers to that. In a general sense, under Boris Johnson, the UK seems to be capable of being more protectionist than it was in the EU. But my second answer, in the technical context of anti-dumping and anti-subsidies, etc., in the WTO, I think not. I mean, you know as well as I do, and Philippe, that in the context of European Commission anti-dumping investigations in the old days of council meetings of the national experts to decide on anti-dumping duties, the UK, Germany and the Netherlands always were liberal and largely promoted free trade, except of course where it had a direct consequence on one of their industries and they were being lobbied up to the hilt. But I don't think that's changed, and I perhaps didn't make the point loud enough, but I have to say I've been quite impressed by the the depth of the investigation that I've seen in the cases I've been involved in. And indeed, it's possible to read all about it on their website, which is really helpful. I don't think the European Commission is quite so transparent as that. I think that the UK has started off, as you say, slowly, and it has started slowly, but I think it's got to start in the right place, bearing in mind that I'd much rather you didn't do anything in this context anyway. Thank you.
Well, thank you very much. And I think we have one final question.
Sorry, I can answer your question, Fergus.
Yeah.
You asked, the person asked about China. If you look on the Commission paper of May 2021,
yes,
which I cite on page 2, footnote 8, it refers to European Court of Auditors report called "The EU's Response to China's State-Driven Investment Strategy."
Splendid. Well, thank you very much. You've done very well thinking on your feet there. And the final question for you, whilst you're on your feet and thinking, which is always the case, obviously, with you, is how would the proposed regulation, or indeed will the proposed regulation, apply to the UK? Because, of course, the UK is a third country, and subsidies given by the UK authorities.
I think my quick answer to that, and I think Mark has already gone thumbs up, like that's a good question. Mark will probably know more about UK trade measures in the context of the TCA, but I suspect that it's a third country, and if UK enterprises fall foul of the regulation, they will be dealt with just like any Malaysian, Australian, Japanese, or whatever company. I don't think there's any specific safeguard for the UK.
No.
Mark, you may have a view on this. You have to unmute.
Well, I entirely agree with you, Philippe, that the UK is a third country, sadly, and so we'll be in the same boat as everybody else.
Yes, indeed. Well, on that boat theme, we're in the same boat, making waves.
3 men in a boat, I think is the answer, isn't it?
No, on that note, I think we will leave it there because it's now 10 minutes past 3, and those are my instructions, and I always obey my instructions. So many thanks to Mark Clough, QC, and Philippe Rutley, and to our chair, Vincent, who is, or I think, is with us. He is. I've seen him nodding. So actually, Vincent, I can hand back to you because you are the capo di capi.
Dear. Where's a defamation lawyer when you need one? Thank you very much to the 3 men in the boat who have certainly steered us very well and very cleverly. And it will be interesting times. And the best way to understand and navigate those interesting times is to be part of EMLO. So in the next while, if you could actually EMLO and become part of the organization, you'll be richly rewarded. So till the next time, be safe and fair sailing.
Thank you. Goodbye.
Thank you. Goodbye.
And bye-bye from me as well.
Goodbye.